Hello. We've already talked about the opening statements, which set the stage for the rest of the trial, and the closing arguments that sum up the trial. Two slices of bread. Let's talk about the meat in between, and that's direct and cross examination. Direct examination is when you're asking questions of the witnesses on your side. The plaintiff or prosecution is called a certain number of witnesses, and they're going to allow those witnesses to tell a story so that we have evidence that's now on the record that can be argued in the closings. The defense is also entitled to call their own witnesses if they so choose and direct examine them as well. So this is the way to get these witnesses to tell their stories effectively. The first thing to consider is, are you able to create a natural seeming conversation that flows well between yourself and the witness? Some witnesses, according to their witness statements, are primed to be sympathetic. For example, victims in non-murder cases, or the family members of victims, or friends in murder cases. If you ask questions of them in a very robotic, unsympathetic way, you're not going to do very well on direct examination. So match your tone to your witness's tone in a way that feels real. Second, don't speak for too long. Different mock trial competitions have different regulations on how many minutes they give for direct examination. But by and large, if you're going over 9-10 minutes in a mock trial context, especially online, not everything's going to stick. Not everything's going to make sense. So think, how can I cut and edit this down so it's as effective as possible? Third, you might consider both exhibits and demonstrative evidence in your direct examinations. There are exhibits that are often included with mock trial cases that certain witnesses are able to talk about if you lay a foundation through questioning. So you can't just start the direct examination and say, tell me what happened when you saw my buddy Alex get murdered. We're missing the foundation. We don't have all of the logical steps to prove that this person was anywhere close to the murder, or they know who Alex is, or any of that. So you have to ask all of those questions, establishing who they are, how they're involved, and laying it out brick by brick, constructing your whole case theory. Some of these witnesses have access to the specific exhibits that can be used in order to add on those bricks to the case theory. Not all witnesses are typically familiar with all of the exhibits. So consider when is the best time to introduce this exhibit with that witness. And in other instances, especially in online mock trial, you might not have an exhibit that came with the case, but you might have some kind of PowerPoint presentation to demonstrate what the witness is talking about. And here's what I mean. In many mock trials, there's a police officer witness, and they have a very strict timeline of what they did as they tried to gather evidence for the case. If you have a PowerPoint demonstration that's a timeline that reminds the jury in simple language, at 1 p.m., here's what the witness said he did. At 2 p.m., here's what they said. 3, 4, 5. Then by the end of the exam, you've got this beautiful looking timeline that will remind the jury about how structured and thorough the witness was, even if they don't remember everything that was said. Fourth thing here on portrayals and backstories. In mock trial, not all mock trial rule sets, but many of them, you're allowed the leeway to ask a couple questions about who the witness is, where they're from, in a way that you can establish their characteristics in a charming manner. So, for instance, my freshman year of college, I played a toy designer witness. The witness statement that I had to stick to was vague about how I had settled on the design for the toys. So I made up some jokes that were true to my character, playing this nerdy little guy, about how he developed these beads, this toy, to help his nearsighted mother tell him apart from his sister. Charming little joke, pleasant story, was not in the witness statement I was given, but I was allowed a little leeway to expand and create a backstory. Doesn't change any big fact in the case, just add some characterization to the witness. Final strategic consideration here is copying to bad stuff. Your witnesses will have to admit to everything that is in that statement. You don't have to bring it all out on direct. You can choose how much you want to bring out on direct examination, but you can anticipate if there's something that makes your witness look really bad, the cross-examining attorney will ask about it. You can pull the sting of that cross-examination by talking about the bad thing first. So for example, if your witness has a prior conviction for lying in court, you know they're going to get up on cross-examination and aggressively say, you are a convicted liar. Isn't that true? You lied in court, right? If you say it first on direct examination, you can take away some of the power. This is a cool little chart about the things you should consider for direct examinations. 1, what important facts do I want to elicit or get from this witness? 2, what do I want the jury to know about the witness as a person? Because mock trial is a scored game, it is good to make them like your witness as a person. 3, how does the witness contribute to your client's narrative? And 4, how should I organize the examination so the jury will remember and understand the important facts? The jury is not going to remember everything, especially during online trials, which means you should start strong and end with the most important, impactful fact. Here's an acronym for you to remember. AURA, attention, understand, remember, accept. The witness should get the jury's attention. You need to make sure they understand what the witness is saying and remember what the witness is saying and accept what the witness is saying. Just because the witness says it doesn't mean they believe it. Some witnesses might not seem credible or trustworthy. If you have an expert witness, for example, like a doctor, they should sound professional. They should sound like a doctor. If you have a sympathetic witness, like the victim that we talked about before, that victim should sound at least a little sad. Something bad has happened. And if they seem completely unemotional, the jury might not believe them. They might not accept what they're saying. So how do you organize the direct examination, this series of questions that you're using? You want to start off by establishing who the witness is. Then you want to lay foundation developing how the witness knows what they know. Hit the climax, the most important, impactful part of their story that the jury's going to remember, and quickly resolve it after you hit that climax. Let's talk about types of witnesses. 2 big types. First, lay witnesses. These are non-experts. They have no conclusion to give based on their knowledge or expertise. They just saw something or they know something, and so they're going to communicate what they know based on the questions you ask them. You want to give the background, who are they? Then you want to lay that foundation of questions, and then give the important facts the jury needs to know. Expert witnesses are different. You also give their background, including their educational knowledge. So if they got a PhD in something, in this mock trial case, you probably should talk about it. Then talk about the facts that they were looking at when they were trying to form their expert opinion. So for instance, if you had a Goldilocks and the Three Bears case, and you brought in an expert who had studied breaking and entering, a criminologist, and they were also experts at looking through finger points and understanding the psychology of criminals, then probably they looked at pictures of the house. Maybe there were some fingerprints along the chair that Goldilocks broke and on the bowls of porridge, and they could talk about those underlying facts. Then they have to describe the procedure that they used. Typically, they're going to give you the procedure in a mock trial case, and you have to establish that they looked at facts, they had reliable principles and methods, and they applied these principles and methods reliably to those facts they looked at. And finally, they've got some big expert conclusion. It's why they were called. Here's how to script the direct. First, on your delivery, scripting the direct. Your voice matters a lot. I used to get substandard scores during my sophomore year of competition because I was very robotic and serious, and I had a very fun and sympathetic witness, and so our voices didn't match. So I recorded myself asking the questions, I played it back, and I heard, oh, you sound so serious. So then I started asking some of the sympathetic questions in a gentler way. I didn't say, so what did you do? I said, so what did you do? Going up like that, change the feel. Second is speed. You don't want to be talking over your witness. It's true, you've scripted out these questions together. You know what you're going to ask. Your witness knows what they're going to answer. But sometimes people get nervous and they speak too quickly. You want to do a game that we call catching the ball. It's not literal, especially over Zoom right now. But the idea is that you ask the question, you toss an invisible ball. They catch the invisible ball, and then they answer the question. Getting that little delayed space in between is useful for judges to remember what you're doing. Nonverbal expressions matter a lot in online mock trial because the judge will probably have a bunch of people in front of them in a gallery view, and so they'll be looking at both the witness who is answering the question and you responding to their answer on direct. You might know exactly what they're going to say and you're bored, but still you have to look engaged. Maybe that's a concerned-looking eyebrow expression, a slight nod. Maybe it's a little bit of a smile if they say something funny, but you have to react to it in real time. Acting is reacting. Body language matters. Again, if you're shifting nervously as you're asking or listening to the answers to questions doesn't make sense. And you can also use body language to your advantage. For instance, if you're comparing a number of things, if they say, as an expert, well, I looked at 3 important facts, then you could say, let's talk about those 3 important facts. See, demonstrated it right there. Silence is a powerful weapon. You can use it to let a powerful answer ring in the jury's ears. So, for example, if there's a statement about police bias, you're the defense, you're trying to show the police were biased against your client. You might ask a question of somebody, they give the answer, and then you pause almost as if you're stunned that such a terrible thing had happened. So to go back to my senior year, when we were trying to prove police bias, there's a question asked of somebody who said, look, I tried to call the police and tell them what I knew about everyone that I saw. And what happened when you tried to call the police? They wouldn't listen to me. They hung up on me. I have no further questions. Letting it sit there for a moment can help the jury process it. Other things for questioning techniques. As I've said in opening and closing lectures, this one as well, simple language. Not, how did you reposition yourself? Did you stand up? Better way to ask the simple question. How did you operate the vehicle? No. How about drive the car? Open-ended questions are the bread and butter of direct examination. It is your job to help the witness tell their story. It is not your job to put words in the witness's mouth. What that means is that you're not saying, then you went outside, right? It's, what happened next? The witness is allowed to say, I went outside. And after you went outside, that's when you saw them committing a murder, right? Don't do that. What did you see when you went outside? I saw someone stabbing somebody else. He was stabbing him real hard. This way, we just allowed the witness to tell the story, as opposed to having the attorney ask leading question after leading question. If you know that there's some parts of the witness statement that the other side is going to object to, you should script out responses in advance so you're able to respond in a fluent and clear way. I'm not going to get into objections right now. It's my understanding we're going to be going over them later. But just know that if you know the objection is coming, the more confident person will have an advantage on the objection argument. So write it out in advance. You're allowed not only to ask questions, but whenever you're transitioning between different pieces of subject matter in the direct examination, you can use signposting. Signposting is saying, now I'd like to talk about something else. Now let's talk about something else. I want to focus on something else. And then you resume asking open-ended questions. So to go back to the Goldilocks and the 3 bears example, if you were direct examining one of the bears, hello, Mr. Bear, could you please introduce yourself to the jury? They introduce themselves. What do you do for a living? Here's what they do. And where do you live? Here's where they live. I would like to talk about what happened on September 7th of 2020. Where were you that night? So you see, I was able to use that header, that little signpost, to preview the next part of my questioning. Looping is what you do when you take something the witness just said and incorporate that into your next question. If you do it all the time, it's annoying, but if you do it strategically, it can be very useful. So let's go back to the Goldilocks example. Mr. Bear, what did you see when you got back to your house? The bear says, I saw my chair was broken, 3 bowls of porridge, totally eaten. And after you saw that your chair was broken and your porridge was eaten, what did you do next? This way I've highlighted that important piece of testimony the bear just gave. Triplets can be useful in question form. So let's use the bear analogy again. The bear goes up, sees Goldilocks in the room, little girl sleeping there in his bed. Mr. Bear, I have some questions for you about what happened when the girl was in the bed. Did that girl ever tell you she was coming over? No. Did that girl tell you that she was going to eat your porridge? No. Did that girl tell you she was ever going to sleep in your bed? No. This way I've asked those 3 questions to establish that this girl is breaking and entering, she is trespassing without permission. And then you're going to end strong. So to finish it off with Goldilocks. Did that girl communicate in any way at all that she was going to be on your property that day? No. She was not welcome. Thank you, Mr. Bear. I have no further questions. We're going to stop this here. We only have 1 lecture left, and that's going to be cross-examination. Thank you so much.